take the pressure off.
Yes, yes. Yeah, you don't want to get burnout. It's not fun. Like we were saying before, it's so important to have that feeling of really relishing your study. And I would encourage you all, you know, in this term, in this unit particularly, but with all of your units, to kind of take that attitude of being mindful of the present moment, where you're at, what you're doing, really, you know, check in with yourself often. One of the things that my study did, I was saying that I've got that paper out, but one of the things that we found in the research that I was doing for that paper was that law students generally have, they are actually more vulnerable than even, than the general population, and also than other students in other disciplines. So even you might think possibly that medical students were more stressed than law students. Actually, law students pretty much win the stress fest. So, you know, anything that I can do, please let me know in terms of support. But one of the really big things is, as I keep harping on about, is just being connected, and that's the biggest thing, I guess, that I wanted to reiterate this evening. Well, welcome to everybody. Welcome to you all at home. If you haven't managed to pop in, that is perfectly fine. If you're watching this, then you know that the tutorials are recorded. So welcome to everyone at home. Without further ado, I will jump into the usual boring few minutes of formal stuff, and that is that we have 3 assessments for this term. As you would have seen on the introductory video. I will mention the dates again because I can't remember who it was and whether they're present, but thank you. I think it was Carlo actually said that we had in the week 1 study guide. Yeah. Oh, okay, Dwayne. Eagle-eyed Dwayne mentioned that there was last term's dates in the week 1 study guide, so apologies for that. But the first assignment date is the 18th of December. 18th of December. The second one is the 22nd of January. And the final take-home paper will be on the 15th and 16th of February. So they are the dates. They're clearly posted on Moodle. So, yep, they are the assignment dates. The first assignment is just the fairly run-of-the-mill IRAC problem question, and I will aim to write that and get that out to you by the end of the week. That is typically on the early term stuff, so I don't make you do pre-reading for that. It's normally stuff that we're covering or should have covered by the due date. The second assignment, I love it. It is court presentations that you have to make. So you do a video of yourself as if you were in court and, you know, actually talking with the judge. I will give you coaching, etc., closer to the date. But what I normally do, it's super fun. So I draft a problem that has no easy solution. Don't you love it when lecturers do that? And I deliberately design it so that it's fairly finely balanced, and so that you can actually choose whether you yes, Emily, I understand that. So you can choose whether you want to act for the plaintiff or the defendant. And then what I get you to do is I get you to enroll in some Moodle fora, and I have a fora for the plaintiff and a fora for the defendant. Or if you wish to spurn off, as sometimes in some terms it has happened, and create your own little Facebook groups for the plaintiff and Facebook groups for the defendant, and then you can all get in there and kind of discuss things, and I'm more than happy for you to do that. As I said, yeah, moots are totes fun. And the more you can discuss things, the better I find is the end product. The more you can polish things up with your other students and bounce ideas off of each other, the better off it ends up in the final product. So as long as that final product is all your own words and there's none of this plagiarism stuff going on and no copying and all that kind of stuff, I am more than happy for you to do things like, you know, peer drafting and stuff like that amongst yourselves, as long as I said, there's none of this naughty plagiarism stuff going on. But law is very much about talking with each other, and that's what I really want to encourage. And particularly when you are in practice, probably my most fun okay, so I'm just thinking, was a defamation case that I ran, but behind the scenes there is so much frenetic research and talking and discussing, and what do you think about this, and what about if I present things that way. I wanted to capture some of that for you guys, and so that's how I normally run for the second assignment. So I normally set the video length at somewhere between 8 to 10 minutes. I haven't drafted it yet, so I haven't decided on the length, but that's assignment 2. As I said, I will provide loads more support and instructions for you closer to the time. I don't release that one before the end of the due date for the first assignment, because otherwise I find people just feel a bit overwhelmed. So I like to do things kind of release them sequentially. So I will release the first assignment by the end of this week, and then the second assignment I'll release after you've handed in the first one, and then the take-home paper is February, which seems like, you know, ages away, but I'm sure it'll be upon us before we're all, you know, ready for it. So that's the assignments. Did anyone have any? Oh, and you guys will know, I don't know whether you do know, bonus, we get 15th and 16th of February. Isn't that Valentine's Day, or is that 14th? It's 14th. So you get to have your love, and then you get to do your assignments. Oh dear, oh dear. But you get those 2 days. From next year onwards, I believe I hear talk on the streets that we are reducing our take-home papers to 6 hours. So there you go. We have a little longer for this term. Any questions on the assignments? Probably for the best, really. Yeah, it gets it over and done with, doesn't it, really? Oh, you get to don the Louis Farrow suit. Nice. Okay, so that's assignments. As I said before, the first assignment, please do read my top tips document, because that'll give you a good idea about what I look for when I'm marking. I guess that's probably about all I wanted to say, apart from your weekly, the way that you tackle your weekly work in this unit. And I did say it on Moodle, and I did say it in the study guide, but I'll say it again, Sam. Actually, that wasn't directed only at Sam. That was just a cliche. Sorry, Sam. But really, if you want to pass this unit with good, solid grades, just reading the study guide won't get you by. You need to appreciate that you need to put in the work for this unit, and nothing can act as a substitute for actually reading the text and reading the casebook. And if you think that's tough, man, wait till the later year units when they throw you into actually reading the whole of the cases online. So at least the casebook gives you the extracts that you need for the purposes of this unit, and you don't have to wade through cases online that have all sorts of other issues thrown into the argument. Dwayne's saying high court decision tennis is great. I know. So please make sure that you do set aside enough time. It's a 6 credit point unit, so it means 12.5 hours roughly of study per week. The way I would do it is I would watch the videos first. so that then you've got a bit of a bird's eye view of how the text works. And if I have a problem with the text, and yes, I have a few problems with text, that's okay. I will tell you in the video. Don't worry about reading this bit, or if you're really confused about that bit, well, this is what it means. Don't worry about reading this part of this case and so forth. So watch the videos first. I would then recommend reading the text and the case book, and then I would actually get on to, if you're short of time, I would get on to your tutorial work. I really do, I can't emphasize enough how important it is to actually, chapter 13 is huge, that's right. That's why it's important, Kathleen, to actually religiously go to the reading schedule that I've prepared for you, which is in the unit profile and also in the week 1 study guide, and actually follow that week by week, because what I've done is I've told you recommended pages to read for each week, and it will iron out those lumpy weeks for you. So try and stick to my reading schedule. That will really, really help. But I was saying, really make time to sit down and actually crank out an answer to each week's tutorial problem. Nothing can substitute for IREC practice. Practice, 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 practice. The more you practice and the more you shift from that mindset of just passively reading something to actually trying to figure out and use the information that you've read, the more you will engage in deep learning. And that's what you really want from this unit, because I can't tell you enough. Contract law is the basis of just so much that you will do in practice and in real life. I mean, you think of it yourself. You can't, you almost physically can't go by a day without making a contract of some description. Even if you just pop in to get petrol and put petrol in your car. I mean, there's contracts there. So, you know, it's part of the fabric. Yeah, Dwayne's in retail. So, you know, it does form so much of your understanding as a lawyer. And so this unit, more than probably almost any other, is something that will be the bread and butter of your practice if you go into practice. So you want the deep learning. You don't want this to be one of those units that you just leave to the end and then all of a sudden cram, and then you go, woohoo, I passed, and then you forget it 3 weeks later. You know, you really want this stuff to go into your brain, into your soul, and you want to meditate on it day and night. Because it will help you. It really will help you. And the analytical thinking that you get out of this unit, if you put in the work, I guarantee, if you look, and I haven't included a reflection at the end of this unit, but I wish I had as an assessment, because I can't tell you how many students have actually emailed me at the end of this unit and said, I can't believe how much my analytical skills have grown. And if you can honestly sit down and say that to yourself at the end of the unit, I don't care what grade you get, but if you can sit down and say, I really feel like I'm more confident in my analytical skills, my problem answering skills, my job's done. Okay, I really think that's super important. Yeah, Emily's saying the degrees already helped so much. This is why I think, sorry, jump in.
Are you happy? I don't want to create too much work for you, but if we send you like a weekly IRAC, like a fully done one of the topic, and just get some feedback at all, would you be happy to do that?
Yes, absolutely. And I've already had some this week. What I will say is some rules around that. What I have found is that in past terms, when I've made this offer, there is a certain contingent of student that will sit down for like 5 minutes and tap out just anything that comes to mind. And it's almost gobbledygook. And so I've got to sit there and try and really work out what's being said. So what I would ask is, if you're going to, and I'm happy to give you my time, but if I'm going to give you my time, what I want from you is to bring your A game. absolutely bring your A game. By that I mean, don't just do it 5 minutes in 5 minutes, you know, at 1 a.m. in the morning after you've had a few on a Friday night. Okay, I want you to actually go write it, proper structure, proper IRAC structure, and do a spell check, do a grammar check. If you can do referencing, I would prefer that, because I find that the students that actually do the referencing for their practice IRACs for me absolutely get better grades in their assignments, because I mark on referencing. Proper referencing is not a luxury. It's an absolute necessity as a lawyer. So that's what I'll need from you guys, a properly structured, well thought out response, as though basically this was your little mini assignment for the week. And I can tell you right now, the students that do this, that really try hard, they actually, their grades up. Sorry, Dwayne, what are you showing me?
This has been a godsend. This is a referencing guide that you can actually get from CTE Library.
Oh, yes, for
it is the best.
For age
it gives you, yep, it gives you absolutely everything, and you can even use it as a cheat sheet. I love it.
I can see you've laminated it, so.
It actually comes laminated.
Late night coffee spills, not a problem.
all of your flow charts are all laminated.
Oh, that's hilarious. That's hilarious.
Well, if I ever come to doing invigilated exams, I could just take the whole folder.
Oh, open book exams. Yeah, don't like those much. Harry's saying he got that too. Okay. Someone's glad that we don't have a reflective task this term. I think you had one for contract A, didn't you? Oh, you didn't this time. Oh, some did, some didn't, just depending on
contract A had a reflective. No, it didn't. No, torts did. Torts
B
did.
Okay. Yeah, I kind of like those, but anyway, you can just write a reflection for me in a personal email at the end of term. Okay, so that's about.
I just saw an ask for scanning that one. I kind of can't, because they kind of get a bit dirty about that. You're not actually allowed to. So I would, but yeah, the uni might get a bit cranky.
I think you can get them directly from, can't you though? So it doesn't matter. You can just
they're $10. So you go to the library, you can order. It's like $10. But when you get your book lists and stuff, you go there and they'll actually offer it to you. So there's a few that I found have been quite valuable.
Yep. So get in early, get in often with your practicing of your citation method. Okay, so that's about it for the nuts and bolts. Now, I unfortunately flagged for you that we'll probably go over time this session. So does anyone have to run away to a subsequent? I have a couple of people. So why don't we cut to the chase? And we can quickly view the video for this week. Before we do so, can I just get a quick idea of how many people have managed to do a bit of prep? So if you've done some prep for this, can I have a 1 in the chat box? If you haven't, do a 2. Doesn't matter. I don't really care. It just helps me pitch the right level of conversation. Oh, look at all those 1s. Yeah, that's what I love. You guys are stellar. This is awesome. Wow. Okay, this is definitely going to be the best iteration of contract B. I can tell already. I'm going to share my messy screen, and we shall go and have a week 1 tutorial video, hopefully popping up. All right, here we go. Can we all see that?
Mitchell. Actually, I'm generally known as Lord Mitchell of the 7 Golden Orbs, but you can just call me Mitchell if you wish.
Thanks. Do you have a legal problem I can help with?
Indeed I do. No doubt you would be aware that the author Jordan Roberts has recently completed the most recent Wheel of Thrones book. It's called On the Limb of Prophecy. Have you read it yet?
Actually, no, I haven't.
You'll love it when you do. It's his best yet. Anyway, recently I found out that Jordan Roberts was going to do an impromptu book signing right here in town. Did you know that?
No. Somehow I didn't hear about it.
Seriously? You missed out. Anyway, the book signing was meant to be at 10 o'clock, but at the last minute I couldn't find the jeweled scabbard for my sword of justice and heritage. I wanted to go in costume. you see.
I'm sure that was very impressive.
You know it. Anyway, with the delay finding my scabbard, and the fact that the digital watch just wouldn't go with my warrior costume, I lost track of time and I arrived just after the book signing had finished. I was devastated.
I'm sorry to hear that, Rachel. It must have been disappointing.
Yes, but all was not lost. Next thing I knew, some guy was waving to me from a nearby coffee shop. He was in his late 40s, had a beard, dressed for business. I went over, and he introduced himself as Jordan Roberts. I was stoked. I did a double take. He didn't look exactly like the publicity shots on the back of his book. But then again, who does, right?
That makes sense. Go on.
So this guy tells me he is only allowed to sign copies of the book at official signings, but he has one in his bag which he signed earlier. It retails for $25 unsigned, but he would let me have it for $100. I thought that was a bit steep, but it was a once-in-a-lifetime chance. I paid him the money, and he added my name above the signature in the book. He seemed like a really good guy. I pulled out my phone and he was happy to pose for some pics with me. Anyway, I rushed home and put the pics up on Facebook. My friends were rather unimpressed though.
Aren't they fans of Mr. Roberts?
Oh, they're all super fans. That's why they were unimpressed. Turns out they were all at the book signing, and this guy who I gave $100 to was definitely not Jordan Roberts. I got completely ripped off.
Do you know who the person was who actually signed your book?
Yeah, he's some guy who works in a menswear store in town. I went to him and asked for my $100 back, but he just laughed and said that I'd agreed to the price. But I only agreed because he said he was Jordan Roberts.
That's quite a tale. Let me think about what we might do.
Okie dokie. So, let's go up here. Alrighty. What we might do is briefly recap the law around unilateral mistake as to identity. I'm hoping that we all identified this as a unilateral mistake problem question. Score 1 for that. Excellent, excellent. Okay, so looking at the law around here, if it's a unilateral mistake, how many parties are suffering under the mistake? Oh, where's the chat box gone? Woohoo! 1. Beautiful, love it. You're all switched on. Okay. The approach of common law, an objective analysis is used. So a mistaken party cannot rely on their own mistake to avoid the contract, even if it's fundamental and even if the other party knew. Looks like the lawyer is also suffering. What are the exceptions here, people? Exceptions to this general position at common law. Are we, oh, can you see which screen are you looking at actually? Can you see my, here, can you see it now?
Yes.
Is that better?
We can see the Word document.
Okay, so which one can you see?
At the moment, this says the highlighted unilateral mistake as to substance, quality, and subject matter.
Okay, so I'm just trying to work out which screen you're looking at. So if I put this document on there, does it say exceptions?
Yes.
Beautiful. Okay. So what are the exceptions?
Like mistaken identity.
Yeah, absolutely.
And
One party must know of the mistake.
Yeah, I'm thinking of the other general.
the documents
Subject matter.
est factum.
Ah, beautiful, beautiful. All right, so what about inequity? Oh, hang on a second. We've got elements here. I think, yes. So inequity. Inequity?
The exceptions in equity.
We can go through that after. If people have time to stay, we don't really need to worry too much about. Rachel's on the right track there. She started talking about unconscionability. Yes, what's the case in relation to unilateral mistake, the big High Court case in relation to unilateral mistake in equity? Good on you, Shah. Love it. Izzy's on it too. Taylor and Johnson, that's it?
Yeah.
That's it? Yep, Taylor and Johnson. So when we're talking about a unilateral mistake as to identity at common law, we've got a stack of elements there. But it's not really quite as simple as that, is it? That you can just plop down the elements and Bob's your uncle. Unilateral mistake has actually generated two different streams or two different categories of unilateral mistake. Contracts concluded by what and contracts concluded by what? Oh, okay, Steve. Bye. Contracts concluded by. Haha, Kurt's got it. Face to face. And contracts concluded how?
In person.
Sorry, I'll put that one down here because that one matches with this case here. And contracts, if it's not face to face, it'll be in. Yeah, Shah's got it again. Okay. Now, where you have a face-to-face negotiation, there's a funny Latin phrase that you need to be aware of. It's called
Inter parentis.
Yes.
Oh, you know what I mean.
inter presentes. And that means you intend to contract with the party that's in front of you. So there is a what? Technical word.
Presumption.
That's it. The presumption that if you're contracting inter presentes, you're going to intend to contract with the party that's in front of you, and therefore
That's the part that can be rebutted. Is that correct?
Yes.
To escape. No, if you can't rebut it, you can't get out of it.
Beautiful. The presumption is rebuttable. Ingram and Little. I love that case. One of my most favourite cases. Why?
Ingram and Little, is that the one with the little old ladies?
Yes.
And the three in the car, and then she went to the back and she tried to find the dictionary to find this guy's name, and came back, and then they said, yeah, that's fine. You tried to do it, and then that was overturned. That's the tennis I was talking about.
Yeah, they checked in the phone book. So the important thing here is to try and scrape up as much evidence that you regarded the identity as material, you didn't intend to contract with the person in front of you, and if at all possible, they knew about all of that. So you're really going to have to try and show that you went about protecting your interests a bit there. And in that particular case, it was checking in a phone book that was sufficient. Yeah, I looked him up in the directory. Yes, Shah's got it. So the case, the lovely bookend case, which courts generally prefer over Ingram and Little. Ingram and Little's really been, has a bit of a cloud over it right now. Lewis and Avery is the case that courts will tend to follow. What happened in Lewis?
That was the one that Lewis sold a car to a Green, R.A. Green, and he he actually took the ID that the rogue actually presented as being that confirming his identity. He then on-sold the vehicle to Avery, and Avery turned out to be a bona fide buyer.
Yes. And who lost out?
Lewis lost out because Avery was the unfortunate third party in this instance, because the title had passed over.
Yeah, so the presumption was not rebutted. the presumption was not rebutted, and therefore, with the dealing inter presentes, unfortunately, it was held that Lewis intended to contract with whoever was right in front of him. Yes. Now, this brings me to a point which I really want people to take home from tonight's tutorial in relation to mistaken identity. Actually, I'll make this a little bit bigger. There we go. And that is, what is the difference between void contracts and voidable contracts? And what is the really severe consequence?
Void is actually usually from the start, so it was never a contract to start with, whereas voidable means that the contract can be rescinded. You can stop the contract from that point on, and it's really drummed into your head in contracts, eh?
Yes, yes, it is, isn't it? That's great. So what does that mean in terms of consequences for the third party on the end of the line? If you do not rebut the presumption and you intend to contract with whoever is in front of your face, okay, that's fine. But if you can, if you can rebut that presumption, you didn't intend to contract with whoever was right in front of you, then the contract is
void.
Yes. And what does that mean for the third party?
That means he has to give the car back because you can't pass title.
Yes, exactly. And if the contract is held to be not void at common law, but voidable in equity, what is the result? And this was the result that they wanted in Ingram and Little.
It gets very tricky because when it's voidable, it means it can be rescinded from that point. But the problem with that was because title had already passed, and that's where it became a bit of a problem, even in equity.
Right, so title can pass, and that means that in the tussle between the person that got ripped off at the start of the contract chain and the end party, if it's voidable, the interference of that final innocent third party will mean that they actually win the fight in equity. They will get to keep title. So when courts are weighing the equities of the parties, what they tend to say is the person at the front of the contract line really had every opportunity to protect their own interests. And the person at the very back end of the contract line, really, they've come into this as an innocent third party. So between those two people, equity will favour that final third party. And it's the intervention of that bona fide purchaser for value and without notice that will win the day.
I noticed that there was a lot of conversation about reasonable time, and that's why equity won't even step in and help him either, because he has to within reasonable time rescind that contract, and he didn't. So that's why he lost. There
is a stack of, if a contract is only voidable and not void, there are a stack of exceptions to a party's ability to rescind a contract. So if a contract is voidable, as the party that has been wronged, you have to put up your hand and say, I wish to rescind this contract. And the court will look carefully at the circumstances, and they will look at this very long list of exceptions to your ability to rescind. And those exceptions include things like what we call latches or delay. If you've waited an unreasonable amount of time to exercise your rights, that will knock you out and you won't be able to rescind. There's just a stack of other exceptions, which we will go into more in the week when we do misrepresentation. Okay. So there is a very large difference between a contract being completely void, title does not pass, and therefore that poor little person at the very end of the line, they lose out completely. If a contract is voidable only, title can pass and the person at the end of the line will win the day. Okay, super, super important to remember that. I won't go into non-est factum and unilateral mistake in equity, because I know that a stack of people have to dash off. In terms of the tutorial problem, let's give it a quick 1 minute once over for those people that are going to leave, and then we can unpack it a little bit more carefully. So we know that this is a tutorial problem about unilateral mistake as to identity. We've just discussed all of the rules. Okay, so give me your gut feel here, people. We know that this is dealing inter presentes, don't we? Lord, what's his name of the seven golden orbs? It's a dealing inter presentes, isn't it? So what's your presumption then?
Well, he intended to buy it. So he intended to actually buy that book from him. So unfortunately, it is actually an avoidable contract, but he's gone beyond the time he actually had reasonable time.
Anyone else have ideas on that?
He intended to deal with the person in front of him.
Yes, exactly. Intended to deal with the person in front of them, and therefore, is that contract voidable or void, or is it valid?
It's a valid contract.
Absolutely. Absolutely. I'm sorry, I'm looking over here because all your faces are over on this screen. Hang on, I'll bring your faces over here. Yeah, we go. Okay, so what do we do? What can Mitchell do? Is there any way that he can rebut that presumption? We know that it's rebuttable, don't we? Megan's saying nothing.
Yeah, AJ, I just, in my response, I think he had to stipulate in the contract that he wanted to speak with the actual, is it Jordan Roberts?
Yeah, and he didn't, did he? So is there anything?
No, he didn't.
Yeah, is there anything that you can point to that tells you, or that a court could find in the extrinsic evidence, that would give some weight to Mitchell's assertion that he only intended to deal with, what's his name, Roberts?
No, I don't think so from the facts that we've been given.
I don't think that there's much that he can scratch up, really, is there? He did say that he remembered that he wasn't really like the photo of him on his profile page.
But he never questioned it.
That's right. So is it similar to any other case? What case is this most similar to?
Lewis and Avery.
Exactly. Exactly. So in terms of Lewis and Avery, you would be then in your application section, you would be talking to me about Lewis and Avery. In cases of unilateral mistake as to identity, where the transaction's face-to-face, there's a presumption, that's the magical word I would be looking for in marking this question, that Mitchell intended to deal with the party in front. The question's whether he's done sufficient to rebut. Then you would be dazzling me with your knowledge of Lewis and Avery. You would be telling me a little bit about the case. And then you would apply the case to these facts. So applying that, Mitchell didn't ask for any proof of ID. So he had done even less than Lewis had done in Lewis and Avery. He even had misgivings about his appearance. So I don't think that there's anything that he could do in terms of rebutting that presumption. If you really wanted to take it up a notch, you might tell me briefly about the Mrs. Ingram. Collectively, the Mrs. Ingram. They call them that in the case. I just have this wonderful picture in my head. I don't even know what they look like, but I'm sure that they got him up in front of, you know, the court and had their little paisley dresses on and presented as wonderfully trustworthy members of society whom the judges felt compelled to help out. I had a similar issue in my defamation case. The lady, who shall not be named, of course, was actively growing marijuana in her garage out at Toowoomba, and the client was Channel 10. They unfortunately said some naughty things about her, which they probably shouldn't have, which resulted in a defamation action. And she was not the most salubrious member of society, but when she turned up to court, she had a lovely white paisley dress on and she had her hanky ready and she was dabbing her eyes occasionally in court. I get the same picture about the Mrs. Ingram. You know, the court felt horribly that they had been defrauded in such a wicked and evil fashion.
Yeah. AJ, actually, this is what's been happening in the Johnny Depp case. They found in favour of Amber Heard. It's the same kind of story, isn't it?
Yes, and the way that you paint your client is so important. And I think whoever was their counsel in that case did a stellar job, because looking at the history of this, you've got to agree, surely looking right back from Phillips and Brooks, that's when people used to, my mother used to be in the retail trade, and she used to give things to people to take home and try, and it was called in the trade, you would give it to someone on APRO, on approval, and if they liked it, they'd come back and pay for it. I mean, this is the kind of thing that the crook was asking to do in Phillips and Brooks. But right from that time onwards, you had a very long history of judges saying, well, hang on a minute, you know, you really got to look after yourself a bit more adequately than just looking up in a phone book. And then you have all of a sudden the Mrs. Ingram charming a court like they did and throwing the case law into a bit of disarray. So if you did want to take it up the next notch, you might just dazzle me with a sentence or two and say something like, look, you know, in Ingram and Little, we had the Mrs. Ingram originally accepting the check, and then one of the sisters said, no, I don't want to take this check, I'm not really sure about this transaction, and then one of them slipped out the back, checked for the name in the directory, came back, and from that very particular construction of facts, then they were held to have rebutted the presumption. Nothing like that's happened here. And so, therefore, unfortunately for Mitchell, he's not going to get his $100 back. I'm sorry, we're 12 minutes past the hour. So that's that. Now, if you want to, I'll just touch base with you now. If you want to stay on, I'm more than happy to stay on for another, 15 minutes or so. If you do want to unpack the other areas of mistake, because as Dwayne was saying, you know, it is a little bit of a tricky area. So if you do want to have a chat about it, feel free. I'm just going to hang around and shoot the breeze. I don't mind if you all go. I'll just talk about mistake on my own. And yeah, if you want to do so, feel free to stay. If you've got to run, also feel free to run. If you have a date with a beer or wine of your choice, feel free to run. Fly, escape while you can. Other than that, if you wish to stay, I will start sharing my screen again. And I will just get back to when we don't have a whole stack of hellos and how are you going and getting to know you kind of stuff at the beginning. The way I normally like to run the tutorials are getting everybody on the same page, and that involves briefly going through the week's readings and giving you an opportunity to ask questions about the week's readings so that everyone kind of is equally happy or equally confused, as the case may be, in terms of the knowledge for the week. Does that sound right and good? Let me just get back on I've lost my chat. Here we go. Oh, bye, April. Okay. Oh, Kathleen, that's fine. No problem. The important thing is that you practiced, and that's worth gold. So please, and thanks for coming. Common mistake. Let's talk about common mistake. Now, what I think I will say before we get into just some general discussions is, also, if anybody needs a bathroom break, please feel free. So, what I wanted to just give you a brief idea of, the way I like to think about mistake, is that generally it's pretty hard to wriggle out of a contract for mistake, whether it be common mistake, whether it be mutual mistake, whether it be unilateral mistake. And the way that I think about it is, generally speaking, the answer is probably going to be no, right? But there are some narrow holes in that blanket no that you can try to drill through. And those little holes, those little rays of light that you might find for your client, are slightly different when it comes to common mistake, unilateral mistake, and mutual mistake. Okay. So generally speaking, with common mistake, again, the answer will be you can't get out of your contract by relying on your own mistake. But these narrow exceptions, okay.
Just ask the Commonwealth Disposals. They'll tell you about that.
That's exactly right. That's exactly right. So common mistake, we have two parties that are mistaken. And these are the narrow exceptions to that blanket no, where you have a common mistake as to what? Of subject matter. Oh, sorry, I'm flipping from the chat to the thing. Harry's saying
The existence.
Existence, that's right, that's right. Yes. And the lovely Latin phrase, race.
Res extincta.
Extincta. Race, it is. Race extincta. Yes. So the result is that the contract is void or voidable.
It's actually void. No. Voidable, sorry, voidable.
Anyone, any other thoughts? Oh, bye, Megan.
Oh, sorry, it's void because it didn't exist in the first place.
That's it. Sandra, you got it right. Generally speaking, at common law, a contract will be void or valid. So far as equity is concerned, a contract will be voidable or valid. Okay, so common law, your consequence is void or valid. Equity, voidable or valid. Okay, so common law, it's kind of an all or nothing affair. Equity, well, it would depend if the person that was wronged actually takes up that opportunity to rescind the contract, and then if they need to go to court to have that voidable contract declared rescinded. Okay. Now, in terms of equity, for those people that are getting a little bit nervous about differences between common law and equity, I have put up a video. It's posted in the week 2 tab on Moodle. And if you have not done equity, I would recommend that you take a little bit of time just to review that video, because it might give you a bit more of an understanding about the way that equity cuts across what we do in contract law. No one expects you to be an expert in equity, but it's good to have some background understanding of the whole development of equity and why we have these two different streams, common law and equity. I mean, why don't we just have law? Okay, so it would make it a lot easier, but us lawyers wouldn't make so much money, would we now? So go and have a look at that if you're a little confused. But at common law, as I said, void or valid. Equity, voidable or valid. Okay, so common mistake as to the other kind of
race sewer.
Race sewer, yep. And that is a mistake as to
title.
Title, thank you, Izzy. Yes, I can see in the chat now. So the result there is that the contract is
void.
That's it. It's not a trick question. Okay. Mistake as to subsisting circumstances. Contract is not a trick question. We're looking at common law. Thank you. Lovely, lovely. I can see you going off in the chat. Common mistake as to subject matter. Now we have a little bit more of a tussle here between common law and equity. Okay. So for res extincta and res sua, equity will generally follow the law. That's a maxim of equity. Equity has all these lovely little curling maxims. And equity will usually follow the common law unless there is something in the circumstances somewhere that will enliven equity's jurisdiction. And then equity is a live matter for us to consider. So generally speaking, for res extincta and res sua, equity will follow the law. In terms of, and also subsisting circumstances, but in terms of subject matter, at common law, it's very, very difficult to get that contract declared void. And that will only happen if the thing that you've contracted for, without the quality that you thought you're going to get, is what? Essentially.
Already owned? I'm trying to think of a case you've got there.
Essentially.
No, different.
That's it. It's a tough one. So this is why I say, if you think of the whole action of mistake being very tough to get around. Oh, okay, bye, Melissa. And you just have these little narrow exceptions. It's a really good way to think about it because it's quite tough to get up on these things. So to try and prove that what you're left with is essentially different to what you thought you were getting is really difficult. What was the contract at issue in Bell and Lever? Can anyone remember? 10 brownie points for this one if you can remember. Oh, sorry, Dwayne. Were you going to have a crack there? Sorry, I didn't mean to cut you off.
Selling something you don't have.
Bell and Lever was the case where the naughty directors got fired, and they were the company tried to get their severance payments back because it realised that it could have just fired these naughty directors because they had been naughty. But instead, they fired them before they realised they'd been naughty.
Yeah, sorry, I didn't get a chance to read that one, actually. No,
And,
my bad.
yeah, and so they tried to get their money back by saying, well, hang on, it's essentially different. We thought we didn't know that we could fire them without severance pay. The court said, no, the result you get is the same. You've severed these employees. The process you've had to go through is the same. So it's not essentially different. You were in a relationship of employment and now you're not. Okay? So it has to be something pretty dire to get you across the line there. What about in equity? Okay, bye, Jay.
Didn't they rescind the contract in that case?
Yes, they allowed rescission. Yes, for sure. So the contract will be voidable in equity if, now we have these three elements that came out of Soleil and Butcher. You had to have a common mistake as to your facts or the rights involved in the contract. And that mistake had to be of a fundamental nature. And the parties seeking to have the contract set aside had no fault. And this is a classic element in equity because there is a maxim in equity. He who comes to equity must have clean hands. Equity is very much about conscience, gut feel, doing the right thing, honesty, fairness, all of that good stuff. And you can't come and ask for an equitable remedy if you yourself are one of the naughty people. Okay, got to come with clean hands. So that's a super important element there. So, which these seem to be kind of, if you think about it, really butting heads, don't they? Because common law says you're almost never going to get out of a contract, only if the thing is essentially different. Like almost never you're going to get up on that kind of a test. But equity is saying, oh, don't worry too much about that. If you can't get a remedy in common law, come to us. We can fix you up. All you got to do is jump over these 3 elements and you might find you got a remedy, just like they gave in Solly and Butcher. So there was this big collective scratching of heads because equity normally does follow the common law, and you can see it's just a protraction of the debate that equity and common law has had over the years, for about 400 years now, of courts being very worried about equity undermining too much the position at common law. Usually the position at common law is the hard-nosed commercial way of thinking, and then equity is very soft and looks like, says, look, okay, that result in common law is very commercially sensible, but look at the realities that the parties are going through. As I said, it looks at conscience, you know, honesty, fairness, all of that kind of stuff. Now you can see if you allow too much of equity to get its way, you're going to be undermining the whole strength of the centuries of common law decision making. So there was a big tussle between the courts of common law and the separate courts of equity at one point, and I go through this in the video. And so there was a collective scratching of heads after Solly and Butcher came down, because the courts were kind of like, well, if you can just get around the common law rule every time, as long as these 3 elements are satisfied, what's the point in having the common law rule? Yes? You understand? You're kind of following me where I'm going? Picking up what I'm putting down? So then we had in the UK this really important decision called the Great Peace decision, and that involved a ship. If you've done your casebook reading, that was the shipping case, one of a number of shipping cases that we do in Contract B, where they actually tried to salvage a ship out at sea that was in distress, and they thought it was going to sink very quickly. They contracted with what they thought was the closest salvage ship, and it turned out that the ship was many hundreds of miles further away than they actually thought. And they were worried about people not surviving and all sorts of things. So they cancelled that contract and tried to contract with the salvage operator that was much closer. Okay, so here, classic case of common mistake. Both parties thought that they were closer than they were, right? However, you have this tussle here, don't you? Was this kind of contract essentially different? Was the fact that they contracted with a salvage operator that they thought was really close and could, you know, get to the distressed vessel quite quickly? Was that?
I think that was the part I was having a lot of hard time grappling with, that great ship, because, you know, they were saying that effectively the contract was still essentially the same, just with different outcomes. And that was the tennis. It was just so forward and back, and it was so hard to really get what they were talking about. And it wasn't until I sort of got about 3/4 of the way through that I realized what they were getting at was the contract was still essentially the same contract with different outcomes.
Yes, and I think you can only understand it if you've already read Bell and Lever, because it's a very strong, what I think that you can see coming very, very clearly through the judgments in the Great Peace case is that the judges were very, very cognizant of the fact that so much of the fabric of commercial society rests on the the confidence that traders place in the common law position. And if you let equity creep in underneath too much and get around that good old dependable commercial common law position, you're going to undermine the reliability and consistency of commercial decision making. And I think that that's the reality of why Great Peace came down the way it did. So they really basically choked out Soleil and Butcher. They said, we think it's wrongly decided, and that almost never happens. It's
especially to Denning.
Yeah, it's very, very rare that a court will out and out say, look, this is wrongly decided, but they did. And poor old Lord Denning, yes, that's one of his big losses. I'm sure he never thought that he was actually wrong, but I guess he would have seen it as a loss. So Great Peace has now taken sway in the UK, and common mistake is pretty much out unless we have the good old res extincta and res sua, the old and the subsisting circumstances. These well tried and true ones they've let through, but in terms of subject matter, you're only going to get through if you pass this very, very difficult test. It's still up in the air really which way our courts are going to go, and I'll leave you to look at the text for more information on that.
So effectively, like a mathematics equation, 1 + 1 = 2. As long, it doesn't matter how you reach 2, as long as that it's the end fact. The end result is the same. It's not going to matter how you change the actual circumstances of the contract. If the end result's still the same, that's going to be the same result at law. Pretty much.
Yeah. Very, very, very hard to get around it. That's why I say the way I like to think of common mistake, and you'll get used to my weird visualizations, but the way I look at common mistake is like a piece of Swiss cheese. Generally speaking, the answer is always going to be, no, you're unsuccessful. But there are just those small holes that you can drill through. And those holes are these three that are very tried and true, and very, very small window of opportunity here. So that's common mistake. Mutual mistake, many mistakes made mutually. Oh, sorry, did anyone have any other questions on common mistake? No? Mutual mistake, many mistakes made mutually. So there might be 2 mistakes if both of the parties are mistaken, but objectively, if they take that fight to court and the court has a good look at what each party is mistaken about, the court might say, yes, it's a case of mutual mistake because they are both making different mistakes. But actually, we think that one party has it right. They're not actually mistaken. We think objectively what they are saying is the case, is correct. Now, if that happens, then at common law, the contract is going to be?
I believe this one was void, if I remember correctly, because if they both can't, there's no contract from the beginning.
If they both can't, so if the court can't physically work out what the answer should be, like in Raffles and Wicklehouse, the ship was to sail ex-peerless from Bombay. That's all well and good, but there was one ex-peerless from Bombay that sailed in March, one ex-peerless from Bombay that sailed in December. There was no way for the court to ascertain which of the parties was correct to give any objective meaning to that term in the contract. So no choice, the whole contract falls over. The whole contract falls over, is void. If the court can work out an objective meaning and one of the parties actually has it right, then the contract is valid. Remember I said at common law, your choices are void or valid. Simple. In equity, your choices are voidable and valid. But in equity, what's the situation? Is there any scope, like in Solane Butcher, where they tried to creep around that common law position for common law mistake. Is there any way for equity to creep around with mutual mistake? Equity will normally follow the law here. So if the common law says it's void, equity will say it's void. If the common law says it's valid, equity will say it's valid. Why is that? It makes sense because remember I said to you, in order for equity to spring up and start having a fight with the common law position and start offering remedies where the common law says there should be none, equity has to have jurisdiction to be enlivened. And in order for that to happen, something has to be smelly. There has to be something that offends one's conscience about the conduct that's happened. And here, if both parties are genuinely mistaken, there's been no shenanigans going on, has there? One party's not trying to trick the
Well,
other.
I think it was pointed out that if both parties are mistaken, you don't have ad idem. You can't be of one mind if you're both making two different arguments. So it's just not possible.
Equity can't be seen.
Can't resolve it.
Yep. That's right, Shah. There's no unconscionability. Exactly. Beautiful technical term there used by Shah. Okay, bye, Emily. We'll wrap it up shortly, folks. So unilateral, we come now to our unilateral, and the only things that we didn't cover previously were non-est factum. We've done mistake as to identity. Non-est factum. What are the elements for non-est factum? Anyone remember?
Non-est factum, is that the deed's not mine?
Yeah.
Yes.
So is that unable to read, unable to understand the nature, must believe it's radically different from what actually it is, not aware of the obligations, and mistake wasn't due to carelessness, e.g. actually reading the document?
Beautiful. Beautiful. Couldn't have said it better.
Go, Carlo. You're awesome tonight,
Couldn't
mate.
have said it better myself.
That wasn't
Lovely.
me, that was Sean.
Lovely, lovely, lovely. So,
Sorry, Sean.
That's all right. I just can't see Carlo's lips tonight.
They're moving.
So Saunders and Anglia is the big case here, as well as Peatland and Cullen. Peatland and Cullen, what happened in Peatland and Cullen? 10 brownie points if someone can give me that one.
He had poor English skills.
Yeah.
And
He couldn't understand, yeah.
the extension on the $50 receipt, which they made him sign and that type of stuff.
But it wasn't a receipt, was it?
No, it was supposed to be. They sent an option. He thought it was a receipt.
They told him.
They told him it was a receipt. Yeah.
Yeah. Naughtiness. Okay, so and Saunders and Anglia, naughty agent. Exactly, that's right, Shah. Saunders and Anglia, or in some databases, this case is called Galley and Lee. Poor old Mrs. What happened here? I won't go into it. What happened here? Saunders and Anglia.
She wanted to
sorry.
transfer the house to her nephew, and then her nephew got a friend called Lee, and Lee was like, sign this, and she could read but just had broken glasses. Yeah, which is quite surprising that it got through, really. But I mean, still fair enough.
Yeah.
To read. So, so she signed it, and then the document was actually transferred to Lee.
I think it was transferred because the outcome of the contract was still the same.
Well, exactly. That's what I'm saying. I mean, you can understand it. Just, it's good that it went through.
Yes. So can you see a little bit of a parallel here in the decision-making on non-est factum to the decision-making back here in
Mutual mistake.
Bell and Lever Brothers and Great Peace? So only if it's essentially different. So can you see the court is taking a very miserly view about letting people off. And why is that? As I said, the need for contractual certainty. Okay, there is still a very big part to play in caveat emptor. Okay, so yeah, very tough to get up on non-est factum. Poor old Mrs. Saunders with her broken glasses, bless. And then the last one was unilateral mistake as to substance is the one I'm thinking here. Substance, quality, subject matter. So the approach is, if a meaning can be ascribed to the T's and C's, the agreement will not be void. That is your position at common law. But then we have equity creeping in, don't we? The creeping of equity. What are our elements for equity to creep in?
The mistake must relate to a fundamental matter of the contract.
Absolutely.
The other party must know about it.
Yes, aware or has reason to be aware of the mistake. And the last one, this is the smell test.
The naughty
One
agent
party
must know about it. Must take measures, does take steps.
Yes, the smell test. Exactly. So there it is. And that is where equity can get its hooks in. The jurisdiction will be enlivened and roars into life. And then you have the possibility of getting a remedy even though the common law would not give you one. Okay.
She was very lucky that equity stepped in that case, because if not, common law would have said tough.
Do you know, I have, whenever I read Taylor and Johnson, I have the same feeling about poor old Mrs. Taylor as I do about the Mrs. Ingram and about my defamation lady. I think she presented very, very well to court and got a lot of compassion on her side, shall we say. I mean, it was a bit rough. She did think she was going to get about 150. She thought she was selling for 150,000. It was worth 195, and the guy was trying to get it for 15,000. So there was a fair discrepancy.
You could almost argue unjust enrichment, really, on a contract like that.
Oh, we will actually touch on unjust enrichment at the end of this unit. So bookmark that discussion. Well, I'm sorry to keep you so long after, but I will stop sharing my messy screen now. I always put these notes up online for you in case you wish to download them and just meditate upon them. Any final questions for this evening before you head off for a refreshing beverage?
Sorry, AJ, I just had a quick one. I was just looking at the flow chart. I know Anthony prepared that, but for the rebuttal presumption for mistaken identity, I think the yes and the no should be flipped.
Oh, really? Look,
I could be wrong, but
I haven't looked at those for years. I have to be honest, Glenn. Let me just share my screen. Where are we? Share screen. Let's go and investigate, shall we? I love a good investigation. Let's have a wee look. So, week 1, flowchart. Nope, flowchart. So where are you talking about? Here, rebuttable presumption.
sorry, yeah, right in the middle down the bottom. So it says, because obviously the presumption is that the contract's formed, they intended to form it. If the contract is, sorry, if the presumption is rebutted.
Aha, yeah, you're right.
Yeah.
You're not
You're right.
going
You're right, Lynn,
insane.
because that was throwing me. I'm looking at it going, this doesn't look right. And I'm racking my brain going, oh, well, it must be right. I'm just going to leave this alone. But yeah,
So
he's
I've
right.
written the cases on that flow chart. I've written the cases on the flow chart, so it's sort of easier to follow and then to go into, you know, the more sort of minutiae later. But yeah, I was looking at it earlier and I was like, well, hang on, if they've rebutted the presumption, then it's void, not the other way around.
That's right. You're right. Okay, thanks for bringing that to my attention. All those that are watching at home, I bet you're glad you got to the end of this video. All right, I'll stop sharing again. Thank you so much for sticking with me to the end, folks. I am sorry it went over time, but you all get extra brownie points in my heart. Okay, woo, let's have some dinner. Woo. I'll see you next week, guys.
Thanks for that, AJ. See you guys.
Guys.